Hi, I'm Les Wilkinson with the law firm of Wilkinson Magruder. We're your Social Security disability attorneys. I'm here with my partner Andy Magruder to tell you what's going on in the Social Security disability world. A lot of new changes are coming down the pike and are here now. So Andy, in a nutshell, tell us what's going on.
Well, Les, there have been a lot of new changes to the rules over the last 12 months that Social Security has implemented, and I can tell you that by and large these rules are put in place by Social Security to make it more difficult for claimants to be approved for disability benefits. Now, one rule that we'll talk about here is the rule that went into effect May 1st, 2017, just a few days ago, regarding the submission of medical evidence before a hearing with the Social Security law judge. Up until May 1st, claimants could submit medical evidence up until the time of the hearing, and oftentimes judges would leave the record open after the hearing so claimants could submit medical evidence after the hearing if that was important to the case. The new rule that went into effect May 1st, 2010 says that all medical evidence must be submitted into the file 5 business days before the hearing unless there is good cause to have it submitted after that 5-day window. So what that means is if you have medical evidence and it's not submitted within 5 business days of the hearing, it doesn't come in and it's not considered by the judge unless you have a very, very good reason for not submitting it within 5 business days.
What happens if somebody decides to go into the hearing by himself without a lawyer present? Does that rule apply to him too?
Well, if someone is foolish enough to be their own attorney and go through the hearing and represent themselves and the hearing is conducted, yes, that rule would apply to them as well, because again, they've gone through the hearing. If all the records aren't there 5 business days before the hearing is conducted, then they're going to be out of luck if they later discover that they should have submitted some other medical evidence. There's also, with this new rule, a requirement that requests for subpoenas be submitted 10 business days prior to the hearing. And there's no good cause exception for being late on those requests for subpoenas. Les, let me ask you, when have you needed to use a subpoena and how is that important in a disability case?
Well, I haven't used a subpoena in a long time because generally we're pretty much on the spot getting those medical records in and harassing the doctors to the point that they'll send us the records.
But there are cases, situations where even if you harass a doctor and I hate to use the term harass, but let's say be persistent with a medical office trying to get records and they don't comply, sometimes you have to request that the judge subpoena the records just to protect your client's interest. And again, if you've not submitted that subpoena within 10 business days of the hearing, then it can't be considered by the judge.
And I will say that you get a notice of the hearing, and even if you're not represented, they tell you what the rules are about submission of evidence before the hearing and the time limits. So everybody's on notice whether you got a lawyer or not.
Right, and one thing about the rule that is of a benefit to claimants is prior to May 1st, 2017, Social Security only had to give claimants 20 days notice prior to the hearing. With this new rule change, they're now giving claimants 75 days notice of a hearing prior to the date of the hearing. So it's important, once someone gets that hearing notice, if they don't have an attorney, to get one immediately so that attorney can gather the medical evidence. Because I tell you, it's going to be really tough on claimants who wait to the last minute to try to find a lawyer, because lawyers are going to be extremely hesitant to take on cases with this 5-day submission of evidence rule.
Okay. Well, thank you, Andy, and we'll take on another topic in just a minute.